2019.
As the court pleases.
Yes, I think it's yes, can you hear me?
Yes, my lord.
Yes, LA stroke 100 stroke 2019. So is the are parties present?
The parties are present, my lord.
Okay, parties are all of them?
No, the claimant is present. The plaintiff is present.
Okay, you are the claimant.
Yes, that's my lord.
Okay, claimant. And the defendant is absent or represented?
The defendant is represented, yes, but the defendant is absent. The second defendant is absent.
Okay, the first defendant is presented by counsel.
My appearance, second, my appearance is for the second defendant.
Okay, but the counsel for the first defendant is not here. Amobi Ogudu is the person that appeared on the last agenda.
Yeah, my lord, he's not here.
Okay. No, I mean the defendants are not in court personally.
No, my lord, they are not in court personally.
Okay.
But they are not in court, but they are. I'm representing the second defendant who is not here present.
I come to that. It's okay. It's okay. So, claimant present, defendants absent.
Yes, my lord.
So, Mr. Clement, are you are? Is there any counsel, or you are appearing for yourself?
My lord, I have a counsel in this matter, but I think the last time I spoke to him was on a flight. He assured me that as soon as he gets off the flight, he will join the proceedings. So to that extent, I'm here in person. So given that it's a ruling, I'm also capable of taking down the ruling.
Yes, there's even a case I saw one. It said Aguan something that a counsel can, can appear for himself in a matter, he's involved in, it's like one Aguan something. So if Aguan isn't one and one other.
Okay, that's called business.
So maybe if you want to announce your, appearance for yourself, I can recall that.
With the kind permission of the court, I would like to do that. Okay,
you are.
Ikeme Stephen Woyi.
Okay. Ikeme
Funa.
Yes.
Stephen Woyi.
Yes.
For himself.
Okay.
As a claimant.
Okay. Yes, Mr. Chizelu.
My lord, I appear for the second defendant.
Okay. So this is my ruling.
As the court pleases.
As the court pleases.
By a motion on notice filed on 29th of July 2021, the claimant praised this honorable court for the following orders. Number one, an order of court granting leave to the claimant applicant to amend the general form of complaint issued on the 11th of March 2019, and other supporting originating processes to which the statement of facts, the witness statement on oath, and the list of documents to be relied on at the trial, as highlighted by the underlining of the alterations in the proposed amended general form of complaint, proposed amended statement of fact, proposed amended witness on oath of the claimant, and proposed amended list of documents to be relied on at the trial respectively. All attached to the affidavit in support of this application are marked exhibit IS1, ISN1 to ISN4. And for such further order or others at this honorable committee fit to make counsel to the claimant file a 12-paragraph affidavit in support of the application and attach the proposed amended processes as exhibit IS1, ISN1 to ISN4. A written address was also filed to accompany the application. It was averred by the claimant applicant that the amendment is necessitated by the need for all relevant facts to be presented to the court so as to secure substantial justice and settle the controversy between the parties and related issues. The other counsel for the claimant in written address raised a long issue for determination to a court whether the applicant has made out a case to entitle him to the reliefs sought. Counsel referred to Order 26 Rules 1 and 2 of the rules of this honorable court in the case of Oja and Ayo, Ogun and Ogun Timein and Guberi, UBA and Dafiaga, to submit that the reason for the proposed amendment is to ensure that all relevant facts and tribal issues are before the court. Counsel also submitted that where a claimant finds it necessary to revise his own pleadings, he can amend his case before the action proceeds to trial in order to bring out the real question and controversy between the parties. Submitting further, counsel stated that amendment would be allowed to correct slips, blunders, errors, omissions, and inadvertence of counsel once the court is satisfied that no injustice will be occasioned on the adverse party. It was further stated that amendment may be allowed at any stage of the proceedings, even on appeal, citing the case of Egwa and Edward. In opposing the application, the first defendant responded on the 16th of October 2021, filed a counter affidavit to the application and attached exhibit BO1 and BO2. It was survived by the first defendant that amendments are not necessitated by a need to do substantial justice or settle the controversy between the parties, but are abusive, inconsistent, useless, and sought in bad faith, and intended to further confuse the matter and overreach the defendant. It was also averred that the amendments are intended to present a different and inconsistent case from that contained in the original processes, and to also introduce unconnected and false allegations of fact that occurred after the commencement of proceedings. A written address was also filed wherein counsel to the first defendant raised the sole issue for determination to it, and I quote, where the proposed amendment ought to be granted, unquote. Counsel listed very many reasons why this court should refuse the amendment sought by the claimant. The reasons are those: number A, that the proposed amendment seeks to overreach the first defendant. Number B, that they are abusive of the court process, and this court lacks jurisdiction to adjudicate the claim if amendment is allowed. Number C, that the proposed amendments intend to present a different case or cause injustice to the defendants. Number D, the application is brought malified. Number E, that the proposed amendment will necessitate the adduction of new evidence, many of which are not within the control of the defendants, to whom the claimant has purported to give notice to produce them. while some of the other documents are public documents which the claimant could seek and obtain by himself. Others are covered by client counsel privilege for which consent should be first sought and obtained. Number 8, that the proposed amendment will prejudice the defendants and delay fair trial of the action, and that the injury to the defendant cannot be compensated by cost. That the proposed amendments are otherwise inconsistent and useless. Number 8, that the claimant intends to use the proposed amendments to introduce false and defamatory matter to the records of the court while using the entire proceedings to secure needless and privileged publicity to defamatory matter so as to harass and embarrass the defendants. That the proposed amendments are unnecessary, scandalous, frivolous, and vexatious. That many of the allegations of fact allegedly took place after the commencement of proceedings and are unrelated to the course of action originally submitted to the court for adjudication. That the allegations bordering on personal income tax of the claimant are not litigable at this court and by the claimant. Consequently, this court lacks the reason to entertain them and cannot give permission for the claimant to amend his case just to bring the allegations. Counsel relied on Order 26, Rule 2 of the rules of this honorable court and submitted that a court may refuse an application for leave to amend process at any stage of the proceedings. Counsel referred to the case of Yamabo and Omorui and Order 13, Rule 18 of the rules of this honorable court. On the definition of overreaching, counsel referred to the case of NIWA and SPDCN Limited and the case of Yusuf and Adegoki. Counsel also submitted that the amendment is sought in bad faith and calculated to introduce new issues which are already before another adjudicating body, LPDC. The new issue of alleged defamation sought to be introduced is already a subject matter of the Legal Practitioner Disciplinary Committee of the MBA. Another counsel argued that claimant is not permitted to approbate and reprobate in the conduct of his case, that having taken the first step to resort to report to the LPDC, the issues before the LPDC have become subjudiced. And such issues should be determined by them. That LPDC is a body established by law to exercise disciplinary jurisdiction over matters of the legal profession, and where a statute prescribes a legal line of action for determination of an issue, the aggrieved party must exhaust all the remedies in that law before going to court. That the LPDC is established by law. It is the submission of counsel that an amendment sought to derail the proceedings is brought in bad faith and it should not be granted, citing the case of UBN and Coleoso. Counsel for the second defendant associated himself with the submission of the counsel for the first defendant and urged the court to refuse the application, even though he did not file a counter affidavit to the claimant's application for amendment. Decision of the court. I've gone through all the process file and exhibits attached. I've also read the submissions of respective counsel for the parties. In determining this case, this application, I need to refer to Order 26 rules 1, 2, 3, and 4, the rules of this honorable court. They provide as follows. Number one, an amendment may be allowed where its purpose is to determine the real question or issue between the parties and would A, secure substantial justice, or B, settle the controversy between the parties and related issues. An amendment may be refused where it would A, present a completely different case or cause injustice to the other party, where the application for amendment is brought malified. B, necessitate the hearing of further evidence, especially on appeal. C, not cure the defects in the procedure sought to be cured, where it's inconsistent and useless. D, amount of overreaching the other party or an abuse of court process. Number two, a party may any time before, any time, but not more than twice, with leave of court, alter, amend, or modify the party's ordination and all other processes. provided that the party may not completely change the course of action endorsed on the process. Number 3, the court may at any time and on such times as cost or otherwise as the court or judge may think just, allow a party to amend any defect or error in any process, and unnecessary endorsement shall be made for the purpose of determining the real questions or issue in controversy raised by or arising from the proceedings. Number 4, an application for leave to amend may be made to the court at the trial, and such application shall be supported by an affidavit with the proposed amendment marked and attached as an exhibit, and may be allowed upon such sums as cost or otherwise as may be just on court. Amendment of pleadings can entail a complete change of the process, even by way of substitution. It can be a simple correction of some lines or paragraphs of a document by adding or deleting letters or words intended to bring out the real issues in controversy in the case for proper adjudication. In other words, amendment connotes an alteration, an addition or subtraction. It has been held to embrace substitution. See the case of Aote and Oduni. By virtue of the provisions of our rules, an amendment may be allowed where its purpose is to determine the real question or issue between the parties and will secure substantial justice, settle the controversy between the parties and related issues. However, it may be refused where it will present a completely different case or cause injustice to the other party, where the application for amendment is brought malified. It may also be refused where it will necessitate the hearing of further evidence, especially on appeal, or would not cure the defects in the procedure sought to be cured, where it is inconsistent and useless. The court would also stop it where it will amount to overreaching the other party on abuse of court process. See Order 26, Rule 1 of the rules of this honorable court. While it is tried that amendment of pleading would not be allowed to satisfy malified intentions, to overreach an opponent, such malified motive has to be clearly disclosed and extracted by the party fighting against the amendment, and to disclose how the amendment will overreach him if it is allowed. From the proposed amended process filed by the claimant and the relief sought in the process, as well as the contentions of the defendants, I'm unable to see how overreaching or malified the amendments are, especially that no evidence has not yet been taken by the court from either of the parties. To me, the amended processes do not present a completely different case, and I'm not persuaded that the claimant's proposed amended processes have changed the nature of the claim before the court. It was held in the case of Alhaji Florishan and Kanubi, Alhaji Florishan, Yanda Kanubi, and Chief Sunday Olagunju, that the fact that the other party's case may collapse if an amendment is allowed is not enough reason to refuse the amendment, and does not mean that the amendment is fraudulent, intended to overreach or be prejudicial to him. It is tried that the courts have always been in favor of allowing amendment, however negligent or careless the sleep, or however late in seeking the amendment, provided that the opponent is not prejudiced. See the case of Celtel and Econet Wireless Limited. The ageless principle of law, which must be underscored, is that amendment of pleadings can be done at any stage of the proceedings, one that is necessitated by the need to bring out the real issue in controversy before the court, to enable the case to be effectively and effectually determined in the interest of justice. See the case of Aquino and Insirim. One of the principles guiding the discretionary power of court to grant or refuse an application for amendment of pleadings is the need to aim at doing and to always do substantial justice by allowing formal amendment as are necessary for the ultimate achievement of justice and to end litigation. See the case of Adomi and Attorney General of Ekiti State. On the contention of the defendant that some of the amendments are outside the statutory jurisdiction of this court, I think I should not address that issue for now, There are several conflicting decisions of the Court of Appeal on whether this honorable court has jurisdiction over a case of defamation. On the whole, it is my view that the amendment sought is not intended to overreach the defendant, but for the effective adjudication of the case. Considering the above, I am of the opinion that the claimant's application for amendment of these processes has merit, and it is accordingly allowed. Consequently, leave is granted the claimant to amend his general form of complaint, statement of fact, witness statement on oath, and the list of documents to be relied at the trial.
As a court business.
As a court business.
Yes. Yes, Mr. Ikeme Funa.
My Lord, I'm most grateful to this honorable court for a well thought out and a well considered ruling.
Okay.
I would want to commend his lordship for his industry and his continued commitment to dispensing justice. Importantly, given the way and the manner this whole application for proceeding has dragged on, I would want to humbly pray this honorable court for cost against the first and second
against the Mr. Chizelu, yes.
My Lord, we are grateful for the judgment, the ruling just delivered. And my Lord, I suppose we are the ones that ought to be asking for costs. The second defendant hereby asked for costs rewarded against the claimants.
Yes,
this matter is a 2019 matter.
Yes,
and they are dragged on.
And it's now going to make you to file further processes. I say it's now going. Yes, so Mr. Mr. Kemi, yes, you are not going to make them to file further processes.
My Lord, the application was brought in good faith, my Lord. So I do not see why you would say I'm the one to pay costs. So cost follows events. The application was found to be meritorious and it was granted by the honorable court. So in the list, parties should bear their costs, my Lord.
Okay. So
my Lord, I think that the claimant pay us costs. Okay. If not for anything, this matter has dragged. It's dragged on for years, and it is due to the delay occasioned by the claimant himself. In fact, it's the application. And furthermore, we are
a quick observation, my Lord. The second defendant did not file any opposition to this application. He did not file any single application.
Observed, we are going to file a consequential amendments that will put us into costs. My Lord, I leave it at the discretion of the court.
Okay, so Mr. Ikeme, we adjourn for what?
My Lord, we adjourn for hearing or for trial. So what with the kind direction of the court, I would take.
No, but can we adjourn for trial? You have not yet it's only the leave that has now been granted.
Granted,
so
yes.
You are now going to file first.
Yes.
And then the need for the defendant to file consequential amendment, they will do. And we're also maybe going to file another
reply.
So better that we take a date for mention to enable the pleadings settle.
As a court pleases. As a
court pleases.
And from the face of the documents, it's like Mr. Ikeme, you are going to have the, bulky process.
Yes, given the particularly the supporting documents. Documents, the various, especially the Court of Appeal CTCs, they will make the document very bulky. So what I hope to do with that is to create a separate bundle for the supporting documents that'll probably be spiral bounded separately, different from the court processes. So the court will probably get parties will also get two bundles. One would be the concise general complaint form, witness statements, and list of witnesses and their statements on oath. The other one would be the bundle of SBs to be relied upon. At least that will make things to be easily handled or managed.
So we're going to adjourn after vacation for mention.
Okay.
If I may,
Yes,
since the Learned Council is talking about bulky documents, we'll be asking for a very long date so that we'll take time to digest these documents.
No.
Yes, as the court pleases, way after vacation, so that we'll have enough time to do justice
so that,
to
the all parties will have enough time to. But from the Mr. Ikeme, you're going to have 2 weeks to file.
2 weeks?
Is that so? I think so.
I would want to indulge the court a month.
You see.
But by the end of the month, I should have my documents in, my lord.
Okay, maybe what you'll do is to. I don't know whether Mr. Chizelu. I should state time in that the claimant shall file within so time, and from today.
I think it will be safer to just give us a date after vacation, because
what I'm
assuming
I know, Mr. I'm going to give you a date after vacation. What I'm trying to say is that, should I state in the proceeding that the claimant shall file within, say, 4 weeks, and the defendant shall also file within 2 weeks from the date of the receipt of the processes, claimant processes?
That should have done it, but we don't know the kind of documents is going to serve us, the weight.
No, yes, but from
the opinion that
from the proposed.
Mr. Cizelu, from the rules.
Yes, from the proposed.
No, I mean from our rules. From our rules, the claimant is going to have only 2 weeks to file from the date of the grant of the application, and the defendants are going to have 2 or 7 days from the date of the service. So what I'm trying to say is that, should I state it in the record that the claimant is going to ask for time to file, and you can also ask for time to file from the date of the service of the, so that any of you will not come to ask for any extension of time again.
Mm-hmm. That works for me a lot.
Okay. So we know how many days do you intend to file, Mr.
I take the hint of the court. So the court wants me to get my documents in within 2 weeks. I would endeavor to do that within 2 weeks. In the event I'm unable to do that, I might just seek a bit of file a motion to regularize it. But I assure the court that efforts will be taken to get.
Okay. So I don't need to give you any time frame to file.
So between now and.
Sorry. I don't need to. Anyway, we can leave it as it is.
Okay, but as a court pleases. But I assure the court that efforts will be taken to file timelessly.
It's like we are going to. The court is going to resume on the. You're going to resume on.
Ruling nǹkan ṣáájú tiwa náà ń ṣe lọ́wọ́.
September. So the court is resuming on the 29th of September. Maybe we should try. Yeah, should we try that one, 29th of September, Mr. Ikeme and Chizelu?
As the court pleases, that date is convenient.
Mr. Chizelu.
Hello, can we come back on the 4th of October?
Mm-hmm.
Okay, 4th of October.
It's a Tuesday.
My lord, and before your brother Justice Elizabeth Oji on the 27th of September. So I was thinking, if not to make things easy, that 27th and 29th would have been a more workable day, but subject to the availability of counsel to the defendants. If on the 4th may also work, but preferably 29th works for me. And it gives me and the other counsel representing me the opportunity to just take both cases at the same time and move on to other things within the space of 2 days.
Yes, Mr. Chizelu.
But I didn't get what Mr. Ikemefuna said, but I suggested 4th because that 4th is very convenient for me. But I leave the rest to the discretion of the honorable.
It's like he's saying that he's going to be in the in the court premises around between 27th and 29th of September. So if that 29th is okay for you, Mr. How do you?
My lord, 29th? Did my lord say 29th?
Yes,
September.
29th September. Okay.
Yes.
29th is convenient.
Okay.
It's a Thursday.
Okay, so Mr. So cases adjourned to 29th of September 2022 for mention. Here notice should be issued and served on the first defendant.
As a call, please.
Okay. Yes, Mr. Achoy. Mr. Achoy.
Case wa non pe the lawyer.
Yes, Mr. Achoy.
Chooks.
Yes, Mr. Chooks. Yes.
Hello, may I? Hello.
Yeah. Okay. Yes, Mr.
May I see of the court to?
It's okay. You can leave. Thank you. It's okay.
All right,
bye.
Most
all right.
Bye.
Okay.
I would also be doing the same. Thank you very much for your time.
Thank you, Mr. Ikeme.
Have a wonderful day, madam.
Thank you. Bye. Yes, Mr. Chooks. Mr. Chukwuem.
Where did you go?
Yeah, you are muted. You are.
I'm so sorry, sir. I'm so sorry.
Okay. It's okay.
Yes, my lord.
Yeah.
Chukwuem Atewe.
Yes,
for the judgment creditor applicant, sir.
Yes.
My lord, sir.
Yes, Mr. Adebola.
Mr. Adebola Odugbeson, my lord.
Okay.
For the judgment, debtor, respondents, applicants. Respondents,
Yes.
my lord. Respondents, my lord.
Okay, respondents, applicants.
Respondents, not respondents, my lord.
Yes. Yes, Mr. Adebola.
My lord, sir, my lord, let me apologize for my dressing.
It's okay, it's okay. It's
Yes,
okay.
I did ask the registrar whether, because on Fridays, my lord, we are to wear native, but if I was coming to court, I will not dress like a Malcolm, sir.
It's okay.
I'm grateful, my lord.
It's okay.
My lord, we did file a counter affidavit to the applicant. We filed a counter affidavit dated the 24th of June, my lord. My lord, sir.
Yeah, I can hear you.
Yes, ma'am. We have two processes before your lordship, sir.
Yeah, they are what and what?
We have a counter affidavit to the committal proceedings, my lord. To the motion on notice.
Yes.
The motion on notice dated 15th October 2021, filed by the judgment creditor.
Yes, which was adjourned for ruling.
I don't know why Mr. Atewa is always in a hurry to commit me.
It was adjourned for ruling now.
My lord, I do very, very much agree with your lordship. I have appeared before your lordship, and I know your lordship's tenacity, my lord. My lord, the papers before your lordship, with the greatest respect, sir. The counter affidavit we filed, yes, we filed a bit late.
And the further
affidavit, my lord, filed on the 28th of June, my lord. We've raised very good.
But okay, but let me ask you, Mr. Adebola.
Yes, sir.
Did you serve the Judgment Creditors Council with your application?
My lord, I made sure that the bailiff of court, knowing the one that I came a bit late, in fact, the default fees we paid were enormous, and I made sure that the bailiffs were duly mobilized to ensure service, my lord. This is in addition, my lord.
You paid 59,000 naira.
Sir?
I say you paid 59,000 naira.
Officially, my lord, officially we paid 59,000, but there are other things that I cannot discuss to my lord since it's unreceived. Since it's unreceived, my lord, I will just let it lie low like that, sir.
Mr. Atewa, are you served?
Yes, my lord. I'm trying to look at the date of
service
of this so-called service. The matter is slated for hearing for hearing yesterday on the Thursday.
Yes.
And the process is being referred, my lord, was served on me yesterday on the 29th. On the 29th. Yesterday, I was just served the processes yesterday. Yeah.
Yes.
So
it's okay, but they are filed on the 28th of June.
Yes. One was filed on the 24th of June. One was filed on the 28th of June.
Okay, yes.
All of the processes referred to, whether by different date of filing, were all served on me yesterday. Both the one filed on the 28th, both the one filed on the 24th, all served on me yesterday.
Okay, then, Mr. Atewa, since you are served, what do you have to say about the documents? Do you intend to say anything?
The processes is in respect of an application that had already been moved and adjourned to ruling. So I don't see how those processes can ordinarily be coming in to arrest the ruling of the court as of date.
Yes, but the only issue is that Mr. Achue, can the court proceed to deliver a ruling?
Yes.
Notwithstanding the fact that the judgment daters of file some process, no matter how frivolous the process are.
Yes, for me, my lord, I believe the court can proceed to deliver its ruling. However, even though the processes actually came in at the date, the court take recognition of those processes at the time of delivering the ruling, the court may simply refer to those processes. But I don't know if the ruling is ready that the processes should arrest the ruling of my lord. But even looking at the processes itself in the instance, with greater respect, my lord.
As a matter of fair hearing, Mr.
Yes, my lord. Yes, my lord.
Maybe if you want to react to the documents, we can follow our joint. Anybody
responding? It's out of time. There's no, I have not been served with any motion for extension of time to regularize the same. There's no motion here, my lord. So as we still talk, my lord, none of the processes filed by the judgment creditor is competent before the court as of this date. Without, for instance, motion for extension of time to regularize these processes.
Yes.
The processes still can't come in pursuit of these rulings.
The only thing is that they are before the court, and the judgment creditors have filed paid the penalty for late filing.
Criminal proceedings, my lord. It's a quasi-criminal proceedings, my lord.
There's no any criminal proceeding act to it. The judgment debtors is in disobedience. It's in disobedience of the judgment of the court.
So
there's nothing criminal. Nobody said he stole anything. It's in disobedience of the judgment of the court.
Yes.
And the courts have made provision that in the event that somebody is disobeying or refusing to
contempt.
That is the point.
Contempt proceedings are serious proceedings, Mr. Tewe.
No, there's nothing a criminal daring.
But Mr. Debola, if you know that the contempt proceedings are serious ones, why wouldn't you comply with the court judgment, Mr. Debola?
My lord, sir, let me commend my learned friend, Mr. Tewe. I have regards for him. I commend his patience all through these proceedings. And I also thank my lord, because for a judgment that was given in 2018, my lord.
Yes.
For committal proceedings that had to commence, my lord, I cannot be given excuses because, yes, I'm in the Attorney General's office and the Director of Legal in the Ministry of Defense. I can be given excuses that maybe those that were before me did not do what they ought to do. That is not the court's business. But when we try to see
it was Mr. BC that I say it was Mr. BC that has been appearing, Mr. BC.
Yes, my lord. Ogunlawo. In fact, my lord, I had to even depose to it in the affidavit that the man had an unusual ailment that defied medical orthodox medicine. As I'm talking to you now, is between life and death.
Which man?
Ogunlawo, my lord.
Okay.
So I had to now take this matter up, came in from Abuja to Lagos, and went through the file. My lord, in saying that I commend my learned friend, it's not because, I'm filing things late. No, I could be on the other side tomorrow. So I must commend his patience, because we had to take some time again to see if we could actually settle this matter out of court. But unfortunately, we could not make a headway to settlement, which I would have preferred. So, but then going through the files, my lord, we had to now file these processes, since we now knew that, yes, there were serious points of law that could be raised, and then we did move, we compiled the records, and I'm sure the records of appeal has also been served on him. So what we are just pleading for is that this matter be had on the merits. I take note of his strong submission that probably we will have come for an extension of time to bring in our counter affidavit. But my lord, committal proceedings are quasi-criminal proceedings. The necessity for application for extension of time are always obviated, my lord. They are always obviated, my lord, in the light of the fact that, yes, there is a likelihood of deprivation of the liberty of an individual. That is why the court is always extremely flexible when it comes to committal proceedings, my lord, when it comes to committal proceedings. But we will satisfy your lordship. We have filed a further affidavit. We have filed our counter affidavit, and all we are praying your lordship to do is to hear us. And one way or the other, I am sure that we will have been able to convince your lordship, sir.
But Mr. Bola,
sir,
you don't file a motion to extend time to enable you file you just went and paid the penalty, file a affidavit and further affidavit without, you understand? Filing a motion. Yes.
That was the explanation I was trying to adduce to your lordship. That, my lord, the National Industrial Court, the Act and the rules, even they encourage speedy dispensation. And that is why the National Industrial Court has always been a special court, to the extent that there are instances why the court will dispense even with the Evidence Act, my lord. That is how special the court is, that they dispense with the Evidence Act, that if the court is satisfied that it is in the interest of justice, the provisions of the rules are always not dispensed with, but at least set aside for your lordship to consider matters on the merits. The National Industrial Court is a very, very, very special court. The Act provides for it, the rules encourage it, that when it comes to dispensation of justice, the court is not compelled to rigidly comply with the rules of court. And that is why, and there are authorities, even National Industrial Court judgments, that Evidence Act, the court is not obliged to strictly follow even the Evidence Act, my lord, even the Evidence Act, and your lordship knows. So that it is not compulsory that I come in with an application for extension of time, or for extension of time to file the counter affidavit in a committal proceedings, my lord, in a committal proceedings. Drawing strength, my lord, from the National Industrial Court Act and from the rules and from the objectives, my lord, of the setting up of the National Industrial Court. So I pray your lordship to allow these processes to go in and allow my learned friend to respond to it, so that there will be no, because if he fails to respond to the affidavit, well, my lord, I leave that to my distinguished Mr. Atewe.
Mr. Atewe.
Yes,
Mr. Atewe.
He's my friend. He's still my friend. My lord is still my friend.
Mr. Atewe,
because of this
in order to hear the matter on its merit. Yes, Mr. Atewe.
Yes, my lord.
In order to hear the matter on its merit, let's just adjourn to enable you if you want to.
On my own, even the entirety of the suit itself was hard on the merit, and I also take the hint that I even have preferred that this particular application also be hard on the merits. But my query is at the point they are bringing this very counter affidavit and the rest of the yes. So if we are taking that into consideration, my lord, we shall be asking for cost, because yesterday we were in court, and
okay. How much do you want?
Ruling this morning, my lord,
sir.
I'm not.
No,
greedy.
Mr. Debola, wait now.
No, my lord, My lord, I'm sorry. I don't want my lord to encourage Chooks to ask for cost, my lord.
No, I'm going to award
my lord is saying how much. I trust Chooks. He will remove Chooks will cut off my head with money, my lord. And he knows that I don't have money. I've just paid so much to even bring this application. So Chooks, leave costs. You know, we are on Zoom or something. So I don't want my lord to encourage him to say how much because he's my friend.
In that likewise, you should be friendly enough to also assuage my feelings. And when the matter is slated for ruling, you have surreptitiously arrested this ruling today.
Yes,
I should go back home.
But you have done it before.
I should go back home empty-handed.
Chooks, you're an experienced lawyer like me. You have done it before. There was a matter that you had to bring in late application and they didn't deliver judgment. You want me to remind you?
No, there was no such. In fact, my application was rejected, and
Chooks, this was years ago now.
My lord,
this was years ago. You want me to remind you?
My lord, with the greatest respect to my learned friend and the honorable court,
you will not ask for cost from me now.
My lord, I was minded to ask for 500,000, but I will take 100,000, sir. I will be asking for cost of 100,000.
My lord, I'm thinking that for the sake of the friendship between myself and Chooks, my lord should not.
My lord, you will pay the cost and we will still remain friends.
Expenses. I am paying medical bills for Ogunlowo. And I've not even come to meet you that you should put it for MBA should know.
Why should you pay medical bill for Mr. BC?
My lord, you know how the system is. Before
Mr. BC is a civil servant. You're also a civil servant.
My lord, it is not an orthodox ailment. It could not. He's in Ilorin as I'm talking to you now. Ilorin, it has not been, is incommunicado for 3 months now. 3. He's so lean. I was so scared. My lord, I'm being frank, my lord. I don't have any reason to tell lies.
No, the point my lord is making is that it's not your responsibility. You are only
to pay
as a friend in that likewise.
Chooks, you know that if I have to apply that
this man is your assistant to Mr. Ogunlowo should not scuttle my certificate. Your assistant to Ogunlowo as a learned friend, even myself, if I have the opportunity to also be of assistant to him, I can do that. But that should not be part of the proceedings. Yes. So in the likewise of this proceeding, you have arrested the ruling of my lords for today. And so court follow events. With the greatest respect, sir. No, I can't go home without cost too.
No, you can't take cost.
I said, Mr. for 500,000. But I reduced to 200,000.
My lord, sir. My lord, sir.
Mr. Debola.
My lord.
I'm going to award cost.
My lord, on compassionate grounds for Mr. Ogunlowo. I know you should be on compassionate grounds for Mr. Ogunlowo, my lord. On compassionate grounds, my lord.
It's not Mr. BC. It's not Mr. BC that's going to pay the cost. It's the judgment debtors, not Mr. BC.
My lord, what they are facing, I just cannot tell your lordship.
Mr. Debola.
Speak for them in that respect.
Mr. Debola.
Sir, my lord, sir. I seek your protection.
Mr. Debola.
My lord, I want your protection from Chooks.
Mr. Debola.
My lord, I'm obedient to your lordship. Sir.
Mr. Debola.
Sir, my lord.
The judgment debtors are Ministry of Defense, Military Pension Board, Nigerian Army. So what have you got to them with? What have you got to do with them? Just allow them now. I'm not at what cost.
My lord, please. My lord will take judicial notice.
Of what?
Of what? Of our of the way and manner we have taken this matter, and also on compassionate grounds for a colleague.
You who? I'm talking about not talking about Mr. BC.
I know, but I asked for them.
It's not Mr. BC's personal case, Mr. Debola. It's not Mr. BC's personal case.
I know, my lord.
It's against the military pension board and Ministry of Defense. So
they don't have financial crisis, my lord. Financial crisis.
Okay.
Financial crisis. It's a serious matter, sir. So, my lord, Chooks knows that. In any case, Chooks knows that he's also going to contribute for Ogunowo's recovery.
So how much are you conceding to?
My lord, that is why I'm pleading, my lord.
How much are you conceding to?
Okay, my lord, can we make cost in the cost? If
no. I can't make any cost in the cost.
Wow.
I can't make a cost in the cost. I'm going to award the cost right now.
My lord, if my lord gives cost, I'm assuring Chooks that the next time that he falls into my hand, I will also slaughter him. Now that I'm pleading, he's not agreeing, my lord. My lord, I concede for 35,000 naira, sir.
No, my lord, I said from 500, I say 100,000.
No,
that is fair enough.
Chooks, how can you take 100,000?
I said
they are in crisis. Why are you being merciless? They are in crisis.
The Nigerian army is in crisis. The Ministry of Defense is in crisis.
How are they in crisis?
Which Ministry of Defense? Which Nigerian
allow
army
them to decide that. Allow them to decide that.
This is a pensions board case. Chooks, this is a pensions board case. And if my lord gives,
the military pension board, yes.
Chooks, if my lord awards 35,000, they are going to contribute 35,000 for Ogunowo. That I can assure you. Yes. Because I'll collect that money back. Yes, Mr. Chooks, I will collect that money back. My lord, I'm pleading for 35,000 naira. Chooks is my good friend, and I'll collect the money back.
No. Let's. This is a matter of serious concerns. It's a judicial matter.
Yes, I know.
We are talking about judgment of 2018.
I said it even before you said it. I said it. Because I told you
we are 2022.
Yes.
2022.
Don't forget that we're moved to settle.
To be delivered.
Yeah, we're moved to settle.
Respect of
please, don't let my lord,
proceedings.
don't let
you have
my
got
lord
an application
just
a day for the court to arrest the ruling of the court. Have to update your counter affidavit. I'm only going home at a loss. I can't. These persons you are talking about for over 25, 35 years, their pension entitlement have been suspended.
They are only asking for more.
And they have a judgment in their favor, a judgment of 2018, and they are here 2022. And I say, no, these people cannot be a cause. My lord, with the greater respect, I was asking for 500,000. But
they're just asking for more. No, don't let's be too emotional. Let's be professional. Don't let's be too emotional. They're just asking for more.
Emotional. It's not emotional.
No, let's be professional. If you are going to be emotional, I told you now.
I said, my lord, make it 100,000. I was only being fair. I was only being fair.
Orthodox medicine. You are not saying anything about that. You are just hooked up on your own.
Mr. Ogunowo is not a party in this matter. Mr. Ogunowo is not a party in this matter. And if I have the cause of 100,000, I will do well as a friend and as a colleague to assist in any way.
And as also my friend. And as also my friend,
but
you will also assist.
At the point you are coming in that Mr. Ogunowo is not feeling fine, he didn't feel sick yesterday. You just said 3 months ago. And you know that 3 months ago.
Since April. You know he was around.
And you knew that he had a fire that is.
I didn't even know. I got to know through his wife.
Are you aware that the matter is coming up on the 30th of June? And you are saying, you are bringing up to arrest the rule of the court?
Intervention and protection, my lord.
Should I adjourn the matter to which protection do you need, Mr. Debola?
My lord, I need your protection from Mr. Debola. He knows that.
I can only protect you, if you comply with my judgment. That's the yes. So Lord, July.
My lord, I have tried. We always with judgments. It's only the aspect that we feel uncomfortable about that we will just ask for.
Mr. Bola, please I know because of the timelines and all that, but yes. I would like you to serve us with your extension of time. It's part of the rules.
Okay. Yes. Okay, Mr. Chooks, I take that hint. Although
yes, Mr. Debola, you should file your motion to extend time to file.
But the risk of paying default again.
No, you're not going to pay any penalty.
As the court pleases.
You've already paid the penalty. Just to file the motion.
You make me pay. Yes, my lord. I take the hint, my lord.
Yeah, just to file the motion, you have already paid the penalty. You don't need to file to pay any additional penalty. You've already paid. So before so is the after. Should I adjourn to the 10th of October? October 10.
I will take any date, so that my learned friend will know that, Chooks will know that I'm not playing with this matter. Any date your lordship gives me.
October
even during Salah, I can call my lord.
Okay,
I wish your lordship, my lord, a happy Salah.
Yes, Mr. Atewe.
10th of October is good for me. Any date is good.
Mr. Chooks.
Chooks. My lord, he has disappeared. My lord, let's just adjourn and then no more cost.
He's going to reappear now.
My lord, are we invited to Kano for the Salah?
Yes, you're invited.
Yes, my lord. Thank you, sir.
Are you coming from Abuja? You're going to come from Abuja or from Lagos?
No, I'm in Abuja, but my lord, the Jebu people will celebrate Salah with pomp, pageantry, and funfair. So I'll get to Ijebu, then from there I must come to Kano, sir.
But in Abuja too, they do celebrate it now.
Hey, but my lord, I'm not. It's holidays. I must go home.
Okay.
Yeah, I must go home. It is Chooks that will not go anywhere. It's in Lagos.
Hey, you're back.
I was off network. Yes. I don't know what I had.
It's because of opposition that the network went away.
Yes, you were saying that you disappeared, and we should just deal with the matter.
Yes.
So, Mr. Chooks, it's 10th of August. Okay, on 10th of October.
October.
Yes. October 10. That's for further hearing.
For further hearing, my lord.
Yes. Mr. Chooks, is that okay?
Yes. October 10.
Yes.
October 10.
Yes, with 50,000 naira cost, Mr. Chooks.
My lord, the airfare from Lagos to Kano is almost 90,000, my lord. Plus 50,000 is 140,000, my lord.
It's even 100,000 now from Kano, Abuja, Kano.
No, my lord, I'll be coming from. You've not given us airports in Ijebu, so I have to go to Lagos, sir. My lord, I'm grateful, sir. I'm grateful for the indulgence. I'm grateful for the indulgence, and I also thank my learned friend for being professional.
Okay, let's wait for him. Let's wait for
Chooks.
Yes, to reappear.
Okay, sir. It's because of his recalcitrance. That is why the network is going, sir. That's why he has no network.
No, but he has tried. Well, he has tried.
My lord, I agree, sir. He tried. I do agree.
Yes.
Wow. Why is this network? I don't know which network it's using. Barrister Chooks, please reappear.
Who is Jimmy Osisanya?
That's the
man, sir.
That's the claimant.
Okay, so Clement is in court.
Yes, sir.
Okay.
Thank you, sir.
Okay, thank you.
Yes.
Let me put your record that you are in court.
Yes, sir. Thank you, sir.
Thank you. Clement present.
Nice, Barrister Chooks.
I guess the network here is not too favorable.
Okay, you're back.
I'm grateful to the call, sir.
Thank you. Is October 10 okay?
Grateful to me, Chooks.
Yeah, October 10, my lord. That's I was saying that October 10, I'm at the Court of Appeal. It's not comfortable. Yes.
So which day do you want?
Well, I know that they suggested I go with it.
Okay, what about the
before my lord on the 28th of September.
That 28th, the court may not because of the this is we are resuming on 29th of September.
Okay. Yes. Another day before then, okay, on the 3rd of
maybe no, third will be this public holiday now. Maybe we should take the 11th of October.
Yes, 11th October is convenient.
Okay. Mr. Adebola,
you are not going for IBA, Chooks. You are not going for IBA.
11th October is convenient, sir.
You are you going? Adebola, are you going?
I want to go, sir. If Chooks will sponsor me, sir.
Oh, yeah. You see that?
Let me take the dates. I know I will appear before the court. I don't know if IBA first. I should sponsor you to where I'm not going to. Okay. My lord, you see how the mind of my learned friend is working.
How is my mind working, Chooks? My mind is working like your own. Yes,
so, Mr. Bola, it's okay, ba?
Hello, sir.
So cases are adjourned to the 11th of October 2022 for further hearing with 50,000 naira cost against the judgment debtors in favor of the judgment creditors, which shall be paid on or before the next adjourned date.
Yes, my lord. My lord said 50,000 naira, sir.
50 years, just 50. Manage it.
Yes,
just manage it.
I'm grateful, sir. I will manage it, sir, as my lord.
Mr. Bola,
but I only wanted to make the point, sir, that my time began to run against me when they regularize their processes.
No. Your time will start to come from the dates their application for essential time is granted.
As the court pleases.
Yes.
As the court pleases.
But you can still decide, Mr. Chooks, but you can still file your reply in
ordinarily, you know, if they
just file
about 7 days. But once I get to the registry,
no, your time will start to run from the dates their application is granted. But you can still
I think ordinarily now I'm entitled to file within 7 days.
No, they have not yet moved their application to.
Not moved their application.
If I'm placed, my lord, to file the registry will want to know when I was served.
No, Mr. Chooks. Mr. Chooks, can you hear me?
To give the date you are served and it's not within the set, my lord.
No, Mr.
Yes, my
Chooks,
lord.
whatever is the time that you are served.
Yes, my lord.
Your time will only start to run from the dates the court grants the judgment debtors application to extend time. They have not yet filed the application, so maybe we are going to take the application on the next adjourned date. You get it?
Yes, my lord.
So your time will start to run from that next adjourned date that I'm going to grant their application, but you can still decide to file in advance. You can file.
Yes, that is what the registry will not understand. I mean,
what you will tell them is that the judgment debtors application for extension of time has not yet been moved and granted. Yes, for your time to start to run.
Yes, if they agree agree with me, my lord. Now, I will file ahead of them. But if it depends that doesn't happen, I might as well file on the 11th of October. But I will come prepared. But I can as well file ahead. It's enough time.
But the thing is that if you file on the 11th of October, the case may not be hard. That's just my.
No, if I file on the 11th of October, we might get a new date to hear the application. As it were. As it were.
It's okay.
Yes, my lord. Okay. But if I'm able to convince the registry in the thought of my lord, I will file ahead of time. I mean, we'll have enough time. We can do that. Okay. But if the registry want me to pay penalty,
no, you don't need,
event
don't need to pay any penalty.
7 days. Yes,
penalty for what?
They always misconstrue that. But
no. If you will pay penalty, Chooks, you will pay it to me. I will collect penalty from you.
Mr. Chooks, don't pay any penalty. Don't pay any penalty.
Yes, my lord.
His motion has not yet been taken. Motion has
not been taken. You can't
yes. Even if he had filed the motion, it has not yet been granted. And they only start to run from the time that the motion is granted.
We are grateful to the court, sir.
Mr. Bola, you should transfer the money to him now, the cost.
My lord, I will.
I'm going to send my account number.
Your account number, I hope it's not CBN account number.
No, it's just First Bank. It's First Bank. It's First Bank.
So
I will send it to you right away.
Bola and Chooks.
My lord, thank you so much, sir.
I wish my lord a happy vacation.
Happy Salah holidays. Thank you, my lord. Happy Salah, my lord.
Okay.
Thank you so much. Okay. So I wish you all the best. That will be all for.
Thank you. Okay, sir. Bye.
Bye, my lord.
Okay. Thank you. Okay.
Thank you, your lordship. $1 million point of law. Come. Hello.